Is anybody watching or no?
We have to give it a second. Has to like kick in everywhere. Oh, There we go. Hold on 1 second. Oh, where does it show up on the page? Oh, there it is. Okay. I can start the Instagram if it ever starts. There. All right. Well, welcome to what you really want to know. Can I reopen my removal proceedings? We're going to talk about some of the updates with the Biden administration and what we've been doing with immigration enforcement. Before I get to that, first we want to give everybody a few minutes to join, so I'll make a few announcements. The first is that tomorrow was supposed to be originally our episode 9 of Are You Smarter Than a Naturalized Citizen? It has been moved to next week. That's June 30th at 9 p.m. Eastern Time. I'll be posting something about that, so make sure to set your reminders so you don't miss the event. And if you like us and follow us on Facebook and Instagram and YouTube, then you will be able to also watch our lives. And make sure if you like what you see and you feel it's helpful for people, make sure you share this. Hi, Lambert. Thanks for watching. One of the big reasons that we are doing this is because there's been a lot of misinformation out there about if people can reopen their removal proceedings, stop themselves from being deported, terminate their case, all sorts of things. So we really hope to clear up some of those issues. And, if you have any questions, please feel free to ask, but I have to give my obligatory disclaimer that nothing said here today creates an attorney-client relationship. We can give you general answers to general problems. If you have more specific questions about your case and the facts of your case, our contact information will be scrolling across the bottom of your screen this whole time, and we do request that you contact us then, and we'll be more than happy to help you. I'm trying to find the Facebook comments. I can't. Moving on. All right. So if you're just joining us, welcome to What You Really Want to Know. Can I reopen my removal proceedings? And I just gave our little intro that we will be talking about this because there was a new memo released last week about prosecutorial discretion. So, Aaron, I think a lot of people, before we really get into the juice, since people are still joining us, why don't we answer this fun question? What is prosecutorial discretion?
Prosecutorial discretion, I suppose, can be loosely defined as the department's decision to prosecute you in removal proceedings. Basically, whether to enforce the law against you, if you're out of status, to put you into immigration court, to continue moving your case against you in immigration court, or to allow you to continue it on with USCIS, to decide whether to admit someone. I mean, it goes all the way back to the beginning, I suppose, right? Enforcement.
Of course, yeah. It's basically, it's all matters that USCIS has their own free will to make a decision. So the law doesn't say that they must grant you this. It says they can grant you this, or they can do this. So it has to do with both enforcing the law and the decision not to enforce the law. Because as probably everybody knows watching this, if you follow anything about immigration, there is a huge backup in the immigration courts, especially since COVID. At the New York City courts are opening July 6th finally, after being shut for a solid year and a half, which is absurd. Hi, Manuel. Thank you for watching. So we want to clear this up. Most likely, if you hear something that is similar to your case, we still recommend you reaching out to us or another lawyer to clarify if it applies, because these things are very fact dependent. And I'll probably say that multiple times because I don't want that. I think some people do get misled because they hear things and it's spoken in general terms and they don't realize that their situation might be different. And we've been getting a lot of calls about people saying, I read this, I read that. And we just want to clear the air because you should know what to expect and what not to. And hopefully we'll help you guys with that. So prosecutorial discretion goes, like we said, anything from issuing notice to appears in immigration court, terminating your case, closing your case. Zuha, I don't know if I'm pronouncing your name right. Thank you for watching. And also whether to detain somebody that they're going to deport, or detain someone that's here in violation of the immigration law, or not detain them, whether to deport, not deport. So this covers a wide variety.
Good stuff. Like
What?
Join on a motion to, or they can just use their discretion to do good stuff. Join on a motion to reopen. Elect not to, give someone a hard time about 10 years continual presence for, like if they have most of the evidence and it's almost perfectly good enough, and they say, fine, we agree to this issue. Fine. That's prosecutorial discretion.
Right. So a lot of people, if you're watching in removal proceedings right now and you've been waiting forever, you might be, we're going to talk about that in a second. Maybe your case is one of those cases that it's worth writing a motion to DHS, Department of Homeland Security, saying, hey, this is one of the cases that you guys should close or terminate. So we're going to talk about all of that. So I think you understand prosecutorial discretion. It's a very broad term. So I think most people are going to watch tonight, and this is the biggest question we are getting asked lately, is can I get my case reopened? And I will give you the first part of the answer, and Aaron can jump in after. The short answer, I should say, is it depends. Aaron.
I mean, there's, traditional limitations on motions to reopen, limitation to one of them. What's the other one? It has to be within 90 days. No, you got new evidence of changed country conditions. You've got evidence that was not previously available at the time of your hearing, and you've got ineffective assistance of counsel. I mean, those are the grounds for motion to reopen.
Well, right now they're likely to do a little bit more than they have been doing the past 4 years. Back when Obama was president, towards the end of his presidency, they started something called admin closure, and it's probably helpful if we talk about what that is first, because that was one of the big components of.
That has nothing to do with reopening a case, though. I mean, admin closure would be recalendaring a case.
Right, but there's a lot of people out there with administratively closed cases right now.
So the answer is, if you have a case that's administratively closed, you cannot reopen it.
You can recalendar it.
Bingo.
And under Trump, when people would ask us about this, we told them just wait.
Yeah, because
that's time.
Judges run a lot of pressure.
But if you're eligible now for a benefit, then recalendaring your case is not the worst idea. But administrative closure is different than termination. How is it different, Aaron?
Administrative closure means that you have a case scheduled and pending before the immigration courts of the United States. You just don't have a court date scheduled. So let's give a good example. Basically, let's say you're in removal proceedings on a simple visa overstay. You've got a U.S. citizen child over the age of 21 who has filed an I-130 for you, and it's likely to be approved. So we would ask the department to join us on administratively closing the case, and the judge would probably agree to close the case. And what that means is your case is open, you're not scheduled for court. If you've got a pending adjustment application, it will be adjudicated by the immigration judge, and that it's likely your relief, the underlying I-130, is going to be approved. And then basically when it's approved, we would ask to either terminate the case or get a individual hearing to be able to adjust status before the immigration court.
Now, there's actually another option that is discussed in this memo and has been, I've attended a meeting with the chief administration judge in New York City for the immigration court, and they are going to entertain applications where they should be joint motions with DHS, I would assume, but essentially saying, look, I have an approved marriage petition, I'm eligible for adjustment of status, here's my application, can you just issue a ruling to grant my case? And if there's no criminal history, if it's a simple like visa overstay.
Wait, to ask the judge to issue a ruling?
If DHS agrees. So instead of people
agrees, so you don't have to go to an individual hearing, we do it by motion, basically.
So I think our motions will look for those types of cases,
Those
was a
cases.
little different. Yeah.
Most likely, I think the reality is that that's not going to end up happening. I would bet you that the judges are going to be pushing to terminate and then let USCIS do the adjustments, because there are a lot of factors to take into account when doing an adjustment.
But USCIS is already overloaded. That's why they've
We'll
talked
see what
about
happens. We've got to see what happens.
I mean, when I was attended the meeting, it did sound very hopeful that they were really going to be doing this, because they just don't have the space and the time. I mean, especially,
that's why I don't think the judges are going to be able to make those kind of decisions without some sort of a hearing.
I think they're going to be relying on the fact that they're jointly filed, so both sides are agreeing.
That's interesting, because I-45s have an interview. That's really weird.
But if they're in removal proceedings,
and if there's no individual, there's no interview.
No, the I-130 interviews, all the marriage cases have interviews.
That's true. And normally, I guess it really depends on what's happening in your case.
But they're also, I mean, that's the best they can come up with, unless they get a huge budget and are able to hire hundreds of more judges. That's not happening.
No, they would terminate the cases and have it go back to USCIS. That's what's going to happen, probably.
Well, yeah.
And that's what termination is. So that was the difference in administrative closure, meaning you have a case that's in court but not currently scheduled for a hearing. And termination means you do not have a case. They're no longer seeking to deport you per se, like actively. And USCIS gets jurisdiction again to adjudicate the adjustment of status application.
So this new memo actually does talk about certain factors that will generally merit dismissal. So if you hear any of these and you think that this applies to you and you think you may be eligible, that you should contact us privately so we can review the facts of your case, because we're more than happy to file these motions. These are very, very positive motions to file, and people are very happy when they no longer have immigration court. So, so some different categories: military service members or their immediate relatives, and this goes whether you're in the military now or formerly in the military, as long as your discharge was an honorable discharge. And this is an interesting one, because this changes a little something that you said earlier. Individuals likely to be granted temporary or permanent relief. So they talk about approved I-130s, and that you show your eligibility for adjustment of status or through consular processing with a waiver. So what I say that's interesting. Oh, it does say approved I-130. Then if you may be eligible now or in the future for TPS or SIJ, which is temporary protected status, or special immigrant juvenile. So these are listed in the Department of Homeland Security memo that says how they're going to be exercising their prosecutorial discretion. So basically, if you have an approved petition, you're eligible for adjustment, or you're eligible for consular processing, where you have to leave, have the interview abroad, and come back. In your removal proceedings, you may be very lucky to have a huge barrier lifted.
Why? Could you imagine voluntarily leaving the country after being in immigration court? Oh my God.
Well, have an approved waiver and.
Well, I guess if we're going to do 601A or something.
Now, they're also going to look at other things like humanitarian factors. Some of those include health conditions, elderly, pregnant, minors.
Whose health conditions?
The applicant.
The adjustment, the immigrant, or the petitioner?
I believe that this is the immigrant. They do talk about primary caregiver.
That's if the immigrant's taking care of the petitioner.
Yeah, serious.
It's like a humanitarian. That's like a humanitarian parole sort of a ground too.
Right. So
same basis.
This isn't like a separate form of relief. It's just if you fall into one of these categories, they are more likely to exercise discretion in your favor and terminate.
I think the reality is that if you've got a good case, like if you don't have like a criminal ground of inadmissibility or a fraud or misrepresentation issue, or you need to have a real waiver, I'll bet you that these are all going to be working out in our favor.
Yeah, and like another ground
about
victims of domestic violence, human trafficking, or other serious crimes. So people who apply for VAWA, U visas, T visas, and then another thing that we haven't heard much before, is that people who came to the U.S. as young children and lived here continuously. So these are not what you think of when you think of DACA, but there's no limitation on when you can enter the country. But basically, what we've experienced, in practice, is that the longer someone's in the U.S., the harder it is for the government to kick them out, because the stronger their ties are to the country. And that's
cancellation eligible.
Right.
I guess you have to probably, the thing is, and we're going to have to see how that works out, is what they're going to do with people who are EWIs.
What does that mean?
Well, then all these ties and all that stuff are lovely, but if you don't have a ground for relief, you don't have a ground for relief.
Entry without inspection, that's what EWIs.
Yeah, EWIs. Yeah. These other things are all the same, basically. If you're adjustable, terminate the case so you can adjust with USCIS. I mean, it's simple. But if you're not adjustable, then...
Yeah. But who I think is going to help?
Let people be here illegally? I don't know.
I think this is going to help people that entered without inspection.
Do you think so?
Let me finish. Got put into removal proceedings and then became eligible through marriage or something, but couldn't adjust in front of the judge.
So they're not going to deport those people? They're not going to remove them?
Not if they...
You're not saying that, are you? That's a big statement, Amanda.
I didn't say that they have orders of removal. I said they're in removal proceedings.
But if you're an EWI, you can't adjust.
If you get a waiver granted, you can do consular processing.
So maybe they'll terminate, so then people can then maybe apply for a 601A?
That's exactly what they're saying here, Aaron.
What a nightmare they're creating, a nightmare. All right.
That's what they used to do. What are you talking about?
That's a tough one.
That's what
Because if they don't get the 601A, then how are they going to do it? What are they going to do with these people? It's a good question.
That's what they used to do. I don't know what else to say.
Would they just let people out?
I don't know. I'm just telling you what's in the memo.
I don't remember that. All right.
You don't remember applying to terminate? We would admin close the case. The 601A would get approved. We terminate the case.
No, if the 601A didn't get filed yet, I meant.
Okay.
That's what I was wondering. If they would terminate, so then you could file a 601A. That's what I was wondering if you were saying, because that would be just crazy.
No, they never did that.
Okay. That's what I thought you were saying.
It doesn't matter. Moving on.
Matters.
It doesn't matter because we don't really know yet.
I just wanted you to be crystal clear for people. That's all.
Yes, that matters, but this back and forth doesn't.
So you'd file it. Well, it's important. People need to understand.
No, what? Okay, stop, Aaron. We're not arguing right now. We're trying to help people and give them information. So the point is, really?
It's good.
Okay. The point is that they've given us some guidelines in very general. And if you're listening to an ad or any video or whatever, if someone telling you specific things that they're doing,
So let me tell you why Amanda and I wanted to make this video. Over the last few weeks, I've been getting these crazy phone calls from people asking me if they've been deported for more than 10 years, can they now file a motion to reopen? And I said, what are you talking about? For some reason, people have been hearing some sorts of ads by lawyers saying that if you can be here for 10 years, after you've had your removal order, you can then file to reopen. That is not true. And I got maybe 10 to 15 of those calls. Amanda was out of the office on her honeymoon, and I was just like, wow, there's something going on out there. So we need to make a video because that's not true. It doesn't make any sense. If you've got a removal order, that means a judge has told you that you have to leave and has authorized immigration enforcement to execute their duties, right? It wouldn't make any sense for that to just give you grounds to reopen. So that makes no sense. Can't possibly imagine what that is. So if you heard that and if you think that, it doesn't make any sense.
Now, things that they have said was that there are some types of cases that DHS may join on motions to dismiss, whereas the last 4 years there was no chance. Like if you have withholding of removal, for example, we've had clients with withholding of removal who either subsequently got VAWA or had like a U.S. citizen child who turned 21 and then filed the petition that was approved, then became eligible for a green card. Then we were able to get the case reopened, and they would agree. Those are going to be those are the types of cases they're still going to be looking at. And you better have no criminal history. Like
entry with inspection.
You're going to need an entry with inspection for stuff like that, and no other immigration violations. So there's going to be a number of people that it might apply to, but not a crazy amount of people. Now,
well, here's the person. There's one client that it applies to a lot. Let's say you're a person who has withholding of removal granted, and you entered with a visa, but you filed outside of 1 year. Then, after withholding is granted, you get married to a U.S. citizen who wants to file an I-130. Fine. U.S. citizen files the I-130. I-130 gets approved. You can't adjust because you've got withholding, which means the only person who has jurisdiction over your case is the immigration judge or the BIA if it was appealed. In that case, we would file a joint motion request with the Department of Homeland Security, asking them to agree to reopen the case so that we can file for the adjustment. And I suppose we could actually probably do a motion to reopen and terminate maybe so that we can file an adjustment with USCIS. I'll bet that would
reopen, terminate, adjudicate.
Yep, I like it. So those are that's going to be the most common customer for that kind of a thing.
Yes. And, there's sometimes ineffective assistance of counsel. They'll reopen claims if you may have been scared to do anything in the Trump era and now you're,
I don't think I don't think so. If you were during the Trump era?
I'm just talking about the 90 days to reopen. That's all. So equitable tolling.
Oh.
It's possible. We don't know. But that might not. It depends how long it's been. It depends if that's your only reason. It depends if you could show your eligibility. That's why, as I said in the very beginning, every answer is going to be it depends when it comes to these things. Like, can I get my case reopened? Can I get it terminated? Because we really don't know yet. We just know very general guidelines, like we're explaining. And we do encourage you, if any of this stuff does sound familiar to you, like your case, call us, because we're more than happy to tell you if we can do it, if we think it's going to work. And if it's going to work, we're all for it.
We tell you about your case.
Our job used to be so much happier because we got to file these motions a lot, and these
make a lot of sense. It saves the clients a lot of money. It saves the government a lot of time and resources. We don't need to be adjudicating cases for people that don't need to be adjudicated in court. USCIS can handle it. That's what they're there for. It's that simple.
Yeah, and then other types of things that will be nice too is they're going to try to shorten hearings by, let's say you applied for asylum, and instead of going through testimony for every little piece of the case to prove, we'll talk to, as we used to, we would talk to the department.
That's how it goes anyway.
What?
It's how it goes anyway,
Yeah, but it was definitely less communication in the last 4 years, I've noticed, until the pandemic. But we talk to them before and we say, look, what's your problem? Why won't you agree that this case should be granted? They'll tell us, and that will be the one issue we focus on.
Yeah, and that's a nexus issue or something, which is very common.
So, and it's not just your eligibility that we're going to have to show. It's also going to be, it's also good to throw in the humanitarian factors, especially just because you have one arrest or one criminal conviction, if you're still eligible, it doesn't mean that they're not going to do something in your favor. It just means we might want to give extra evidence to say, look, you may have stolen something 20 years ago, but you've done, A, B, and C and rehabilitated yourself. Those
community service, being a really good person, getting a lot of things, evidence in your favor.
If you get anything out of this today, I think it would be that if you think that you might be eligible to have your case reopened or terminated, or to make your life easier, do a consult, a real consult, whether it's with us or with another immigration attorney. But it'll be the best. We charge $250 for a consult, the best $250 or whatever it is that you spend, because then you can be confident that we're not just going to file it just because you want to file it. We're only going to file it if we have incredibly high success rate. We rarely get these things denied because we're going to be honest with you. And you don't want to get into that mess. And because the bottom line is, if it works, as Aaron was saying before, you will save yourself a lot of money. You won't have to go to court. You take a lot of stress off of you and your family, and they really want to. I mean, what they've been telling us is they really want to grant these things.
It's just really not right to tie up the government resources. Also,
they just can't handle it. They have to almost.
We can't handle it.
Like
the immigration stress of dealing with court for cases that don't need to go to court. It's stressful. Right. We don't need that. The government doesn't need that. Nobody needs it.
Another good category that of people who are watching that this might apply to is if you had your I-751 denied, your petition to remove conditions on residency, you automatically get put into removal proceedings. If you refiled it or are about to refile it, even if it's a joint one and there was a reason that got to, it's better the second, whatever, there was a reason it got denied the first time.
Maybe you didn't do a good job.
Like you didn't have a lawyer and you
didn't do any good evidence. You were lazy. You were cheap.
Or you got you broke up while it was pending and now you're divorced, or you were the victim of abuse. Normally your removal proceedings stay open until your I-751 is approved, which means you cannot travel outside the U.S.
That's really what it means.
But if they terminate your proceedings, then you don't have to worry. You're not in proceedings while it's pending. You don't have to worry. And if it gets approved, you don't have to then file a motion to terminate. You're done. So, because remember. And
you don't have to wait for an individual hearing.
Right.
You could have an approved 751, which means it should be slam dunk. You should be able to go apply for naturalization, basically. Yes. But could you imagine you might have to wait another 2 years for an individual just for the judge to stamp the stupid paper?
I mean, they usually terminate it. We filed motion to terminate that.
Yes.
I just know DHS wouldn't consent to it for 4 years, even when there was no reason not to. They just would file nothing, so it would take longer. And instead of the judge being able to see, they consent, I'll sign off on it, it was like, I have to read every word and make sure. So they were unnecessarily making things longer, but hopefully that this means that is now in the past. And then another good thing, if you're worried, if you win your case, what if they appeal? And I know people in detention are especially worried about this because they don't always get released, even if they won because of the appeal. But they are going to be encouraged now to waive appeals in non-priority cases. And real simply, and that's even if they can win the appeal, they said in this memo. And these non-priority cases have to do with, I have it somewhere.
Non-criminal factors, danger to national interests kind of thing.
National security, public safety, and one more. Border security. National security, border security, and public safety. So basically, border security is being apprehended at or near the border of port of entry. And this only applies to people who entered unlawfully. Oh, that's another thing. If you entered unlawfully before November 1st, 2020, you're not a priority. So you're more likely to have your case closed, reopened, terminated, whatever, or not deported. But if you entered without inspection after November 1st, 2020, then you fall into a priority category and you're much more likely to be detained, deported, put into removal proceedings at all.
Yeah, Biden's not playing games, basically.
Right. They're not. They don't want to open.
I was a suck up, but I ain't no fool.
Right. And then in terms of the public safety and national security grounds, were unique convictions, aggravated felony convictions, which, Aaron, would you like to tell everybody what an aggravated felony is?
They can hire me for that.
Okay. I still don't think you'll want to. Aggravated felonies are not defined in the law, but basically violent crime, in a very general way of saying it.
Well, there are defined by law.
Right. Well, no, not at the term aggravated felony, but yes, you can determine. It's a case by case basis, basically. And you have to pose a threat to public safety. Aggravated felony conviction or gang related, gangs too, and you have to pose a threat to public safety. Well, that's a big end. And then national security has to do with terrorism and espionage. So if you're a spy or a terrorist, things like that. And we
had one.
Yeah, I know.
Like a real one.
We had an alleged one.
No, he pled guilty.
So yeah, basically that I think we've really covered everything we wanted to talk about today. There
is another video on aggravated felony. I don't want to get into it, but it's like, receipt of stolen property. If the term of imprisonment's a year, term of imprisonment's a year.
We're not getting into that.
Over $10,000 in fraud.
The point is, if you know the term aggravated felony, then you know it's not a term you want to hear in your case at all. If it is, if it holds.
If it is, you're probably detained.
You're probably detained, and you're
mandatory detention.
It brings very severe consequences.
You can't adjust.
Right.
There's nothing you can really do except for the Convention Against Torture.
So basically, with an aggravated felony, you want to get that taken away before there's a finding on it, as opposed to after, because you have to prove it's not an aggravated felony. But the good news is that there isn't they don't say that doing X, Y, and Z is an aggravated felony. It generally refers to laws. So there's always an argument that it is or isn't.
Sometimes depends on if you've been in jail.
For the most part, yeah. But again, that's incredibly complicated, and you want to make sure you have a lawyer who's experienced in immigration and criminal law in order to.
If you call it up, I'll be able to tell you in about 5 minutes. And
also, ideally, you contact the immigration lawyer before you plead guilty to something, because they can work with your criminal lawyer. And sometimes we do criminal law too, or we work with other criminal lawyers to make sure that whatever the guilty plea is going to be will not hurt their immigration, application.
The adverse consequence in immigration.
Right. And I think that's it. I don't know if anyone else, if you have any questions, we'll stay on here for a few more minutes to see. But the reason we didn't bill this as a Q&A discussion like we have at some of our other lives is because really it's really hard for us to answer questions in this forum, since it is so individual. We need to look at each individual's case and then look at the facts and say, and we know pretty quickly, within 15 minutes usually, if this is going to work or not. And like I said, we generally don't get these denied because we will not file them if they're going to. And I don't know why Goldie's crying. She should be smiling.
You know why? Because she hears your voice.
Oh, she misses me. That's
I don't know if she misses your voice. Also, it was raining, and I was at a client's house until just now, so I didn't walk her. But she has a yard. She's okay. But
you used your discretion not to walk her.
I'm gonna walk her afterwards. Don't worry. She'll get her 7 or 8 miles.
I have no doubt.
That's how you get your like this.
So remember that you are going to save yourself a great deal of energy, time, and money if you are able to get your. Oh, there she is. Oh, there's Goldie.
She's the first dog to pass the bar.
She doesn't know
I
that.
don't ever pass a bar.
Why don't you look at the camera? She's being so weird. I miss you, girl. She used to come to work every day before the pandemic. I miss you, girl. Anyways, I do love seeing Goldie. It looks like we don't really have any questions, although, Goldie, do you have any? She's saying yes.
Good night, everybody.
Thank you all for watching. Don't forget, tune in next week at 9 p.m. Eastern Time on Wednesday, June 30th for episode 9 of Are You Smarter Than a Naturalized Citizen? It'll be Battle of the Franciscos. I'll be posting that either tomorrow or the day after. And if you found this to be helpful and you think it will help others, please share the video, and don't forget to like us and follow us on all the social medias. So
if you didn't like it, don't tell anybody.
You loved it.
That should be our closing every week.
Okay, sure. This has been What You Really Want to Know. Thank you all for watching, and have a great night.